The second case, which is Alexander Walker versus State of Florida.
Good morning, Judge Black, Judge Smith, and Judge Case. My name is Andrew Crawford. I represent the appellant in this case, Alexander Walker. This is an appeal from the denial of a downward departure motion from the 6th Judicial Circuit in Pinellas County, and I'd respectfully request 5 minutes for rebuttal.
All right, you got it.
Thank you, Your Honor. Your Honors, this case involves a denial of a downward departure on the basis of a mental disease or defect that is unrelated to substance abuse, the need for specialized treatment, as well as the appellant's amenability to the treatment. In this particular case, the defense presented testimony from Dr. Valerie McLean. The state stipulated to her qualifications. Dr. McLean specifically testified that the defendant in this case, Alex Walker, was suffering from post-traumatic stress disorder, general anxiety disorder, depression recurrent, and opioid disorder. She further testified that she had reviewed medical records from another psychologist, Dr. Ramsey from Advanced Mental Health, who confirmed her diagnosis. Additionally, the state did not present any type of rebuttal doctor to Dr. McLean's testimony. As the court well knows, in order to depart from the Florida sentencing guidelines, it's a two-step process. Number one, whether the defendant presented sufficient evidence, and number two, whether the trial court should depart.
The judge below sort of, as I read it, observed that there wasn't much to indicate that specialized treatment was needed. It was kind of an unusual situation where the defendant was actually doing quite well. Care to comment on that?
I do, Your Honor. Dr. McLean, the trial court stated that she usually finds the amenability to treatment prong the one that is more problematic, but in this particular case, the court said that Mr. Walker did not require specialized treatment for a mental disease or defect. According to the court, she said he was out on bond for a period of time, and the only thing he really needed was Suboxone to treat the opioid disorder. I'd respectfully submit, Judge Black, that the judge's finding is in contradiction to the evidence that was presented. Specifically, Dr. McLean said that Mr. Walker needed a dual diagnosis program to treat both his opioid addiction as well as the post-traumatic stress disorder and other disorders that he had. And I'd note that Dr. McLean met and evaluated Mr. Walker on August the 8th, 2019, and the sentencing hearing was held on December the 13th of 2019. So she had seen him just before, within 3-4 months of the actual sentencing hearing. And at that particular time, based on the evidence, she said that he needed specialized treatment. The specialized treatment that he needed, she also, I understand it's not a factor for the court to consider, but she testified without objection that this treatment was not available in the Department of Corrections. So she specifically testified that there was a need for specialized treatment, dual diagnosis, which this court has recognized is a specialized treatment, in a number of different opinions, which I've cited in both the initial brief and the reply brief.
I didn't pick this up from the record, but was curious about whether the gentleman has already served his sentence or not, because it looks like it's getting pretty close since he got a bottom of the guideline sentence. If he had any jail credit at all awaiting trial or plea, then he's probably just about out of confinement, I would think.
He's still incarcerated at this time, Your Honor.
Okay.
So yes, he did get the guidelines. He has served some time. However, he still has time left on his sentence. That would not necessarily moot the appeal.
I understand.
In this particular case, the court had it. Yes, Your Honor.
So how are we then to reconcile the evidence that the court heard with respect to Mr. Walker's own testimony, that he, had been doing well. He had not gone to any AA meetings. And I don't even think at the time that he met with Dr. McLean that he had taken the opioid drug, which was Suboxone. at the time of their meeting. So are we just simply to ignore that evidence? Is that what you're asking us to do?
No, Your Honor. I'm not asking the court to ignore that evidence.
How do we reconcile that with the expert's testimony as you're asking us to simply go by what the expert said?
Well, because the expert's testimony was unrebutted, the state did not present a contrary doctor to rebut her opinion. Furthermore, she testified that he did need a dual diagnosis program and met with her 3 months prior to the sentencing in the particular case. There was also testimony regarding his abuse as a child, which was independently confirmed by his mother, which warrants—
When you say independently confirmed, it was not— it was only independently confirmed with respect to Mr. Walker disclosing to his mother after he met with Dr. McLean. This wasn't something that the mother independently learned years prior to that meeting with Dr. McLean, correct?
That may be correct, but still does not change the fact that there is a need for specialized treatment that is unrelated to the substance abuse, which was the point of introducing that testimony from the defense attorney below. But regardless, I'm not asking the court to ignore that he was out on bond during this, but Dr. McLean's professional opinion, which was completely unrebutted by the state attorney's office, was that he needed specialized treatment for dual diagnosis. She is the board certified psychologist, which the state stipulated to her qualifications. The fact that Mr. Walker necessarily did not seek out the treatment during the time that he was out on bond does not negate the fact that he needs the treatment, which is the requirement under the statute.
I think that's the point that the trial court was making below, and that I'm struggling with myself, is that, okay, the evidence from unfortunately for him, I mean, he had done well over those years without the treatment. And so even though the doctor, the expert, is saying that he needs it, he in fact has shown that he doesn't need it because he is doing well.
I understand what the court's saying. I'll respectfully disagree with the court. I want to point out that the psychologist specifically testified that he needed a dual diagnosis program to help improve himself further. Mr. Walker testified he was more than willing to do any type of program to that effect. I would also cite the court to the case law that I've cited in my initial briefs. Specifically, I believe it was the Green case. It's a 4th DCA case from 2018. The struggle for the court, the 4th DCA, was specifically that the state argued that the defendant had not taken his prescribed medication while being in the jail, and he had a history of noncompliance. Nevertheless, the 4th District Court of Appeals specifically found that it was error to reject this statutory mitigator under those circumstances. The most recent case that this court has decided is the Williams case, which came out in 2019, which was a case from Sarasota, Manatee County, where Dr. Renier testified that the individual was suffering from post-traumatic stress disorder, and due to life events, he had self-medicated, which predated, which is precisely what we have here. That Dr. Renier further testified that there was specialized treatment that the defendant needed for a dual diagnosis program. Again, exactly what we have here. And that treatment was not available in the Florida Department of Corrections. The state argued that there didn't appear to be evidence of dual diagnosis and or depression, and the defendant appeared fine. This court nevertheless reversed that case and remanded because the court was under a misapprehension of whether it could depart from the Florida sentencing guidelines, and the court's own statements belied what his findings or her findings were in that particular case. I would respectfully submit that those are, at least the Williams case is binding precedent, and the Green case is persuasive as it relates to this particular case.
Crawford, I had one other observation when I was going through the transcript at the sentencing hearing.
Yes, Your Honor.
The trial judge seemed to have some doubts concerning the fact that she had to impose a sentence that she thought otherwise should have been resolved between the state and the client. What significance do we attach to that, if any?
You should attach a lot of significance to that, Judge Case. That was on page 170 of the supplemental record for the other judges. That in that particular case, the judge asked the attorneys to approach sidebar. She really wanted, it seemed like she wanted to depart from the guidelines, noting the disparity in the co-defendant and that Mr. Walker, this was his first felony. She told the defense attorney that it kind of seemed like she wanted to depart, but legally she didn't think that she could based on what was presented before her. So I think that is another reason for reversal. And that goes to potentially the second prong, which we didn't even get to in this particular case, that if she had the ability to depart, she might have based on that bench conference. So I'd respectfully submit that bench conference is very important to this particular case as it relates to both prongs.
Okay, thank you.
Thank you.
You want to reserve at this point?
Yes, Your Honor.
All right, you've got your full 5 minutes left.
Thank you, Your Honor.
For the state.
May it please the court, Johnny Salgado, on behalf of the Attorney General's office, in this case, Alex Walker versus State. I believe this case hinges on the fact that Mr. Walker did not establish that he needed specialized treatment for a mental disorder that was unrelated to substance abuse or addiction. As Judge Smith pointed out regarding Mr. Walker's own testimony, he was saying that during that 2.5 years while he was in bail, he had gotten clean, he'd become a good father, his marriage was in the best condition ever. That shows, that in essence denies the argument that he needed specialized treatment. When you look at the downward departure statute, the subsection D, which applies here, specialized treatment for mental disorder, it's 3 prongs. The first one is that the defendant has a mental disorder unrelated to substance abuse. And that's even questioned in this case because as we go to the record, when the expert witness Valerie McLean on page 117 is asked, does he meet the criteria for a departure under this section? And she doesn't answer that question. She really goes on to give her diagnosis of him. Then also on page 118, Dr. McLean does recommend continued use of Suboxone. And then on page 119, where the question is asked, it sounds to me like he does suffer from a mental health issue separate and distinct from the addiction issue as well. Dr. McLean answers, well, I don't have independent verification of the sexual trauma, but I do know it was at the ages of 5 or 6. So in essence, the way we have rebutted this evidence of Dr. McLean is, again, that period of time, that 2.5 years while he's on bail, where he's doing well on the Suboxone. So it's our position that he just doesn't establish the needed specialized treatment for a mental disorder that was unrelated to substance abuse or addiction. As Judge Smith, you can't ignore that defendant's testimony in this case. Unless there are any questions from the panel, we're going to rely on our brief and ask that the convictions be affirmed, then the sentence be affirmed.
All right, thank you, sir. Rebuttal, Mr. Crawford?
Yes, Your Honor. Judge Black, in response to your question earlier, Mr. Walker is scheduled for release in July 2021, so he does have a lot more time to serve.
Okay, thank you.
You're welcome. Now, as it relates to the specialized treatment, I think it's very important to note that the state below never argued that there was not a need for specialized treatment. The prosecutor below on page 159 of the supplemental record only argued that the mental health was not unrelated to substance abuse. So I'd like to point that out. In terms of the need for specialized treatment, again, a psychologist, which the state stipulated to her qualifications, gave unrebutted testimony that he needed a dual diagnosis program 3 months prior to the sentencing hearing. She gave testimony as to that fact. Mr. Walker testified he would be happy to enter into such a program, and the defense in this particular case proved by the preponderance of the evidence each 3 of the requirements: mental disease, defect or disorder, which is post-traumatic stress disorder, depression, anxiety, as well as opioid addiction, that was unrelated to substance abuse, which was provided by Mr. Walker as well as his mother. There was a requirement for specialized treatment, which was a dual diagnosis program, as well as other factors contemplated by Dr. Valerie McLean, and he was amenable to treatment. The state actually brought that up during cross-examination of Dr. McLean, and she confirmed that Mr. Walker was indeed amenable to treatment. All 3 prongs were met. The court said that he did not meet all 3 prongs. Based on the case law that I have submitted to the court, as well as binding precedent from this court, I'd ask the court to reverse and remand for sentencing. And unless there's any other questions of the panel, I'd reserve the balance of my time and rely on the arguments contained in both the initial brief and the reply brief.
All right, counsel, thank you very much.
Thank you, Your Honor.
Good to go.